Hello to all our viewers. Hope you're all doing well. We continue to hear a lot of interest on Matthew Massucci's case. We're getting a lot of questions about the case from viewers, members of the public, and from the press. Many of you have seen this series that a local reporter by the name of Dave Biscabine has been doing on Matthew Massucci's case. He's done 3 installments so far and is continuing to work on his case. In fact, Dave reached out to us recently with some interesting information that he's uncovered that we wanted to share with you all. Particularly one of the things that Mr. Biscabine uncovered was some of the email traffic going on in the city government related to Matthew Massucci's case. And he had asked some specific questions about some of that traffic. And one of those was particularly about an email from the Prescott chief of police to a lot of members of the Prescott government. We're going to provide you with a redacted copy of that email. Now, we're not redacting out any of the substantive contact, but we are redacting out things like email addresses and names of minors, those sorts of things, because we don't want to dox anybody. But it was a very interesting email, and I don't know the facts behind the email, but on its face, the email appears to be from the chief of police, Police Chief Bonney, to members of the Prescott city government, providing information about Matthew Massucci's case and about some of the media that's been presented, and particularly the series that Dave Biscabine had done on the case.
I mean, if you had to describe this email in a word or phrase, I guess, what would it be?
Cover up.
Damage control.
So you're going to see a copy of the email, and one of the first things that I want you to note is just kind of the lead up in the email where the police chief is saying that this was a series that was, quote, riddled with inaccurate information, close quote. Now, when someone says this, particularly a police chief, I really expect them to bring the receipts. I expect them to point out this is what was inaccurate, this is what was misconstrued, and those sorts of things. But interestingly enough, in this very lengthy email, I never really see the chief say that this is a piece of inaccurate information. She does say that some of the opinions are inaccurate. Well, that's fair. You can have different opinions, but you don't get different facts. And what she never does say that I can see anywhere is that the facts that either Dave has cited to or we've cited to have been inaccurate in any way. Just wanted to point that out. The next thing is, I'd like you to notice the strategy that the chief lays out fairly early in her email, where she says, quote, soon another headline will take its place, close quote. Now, I can't read the chief's mind, but I can tell you that when I read that email, it sounds like they've developed a strategy to just ignore this problem and maybe it'll go away. But unfortunately, this is not the sort of problem that goes away. You either fix it or you don't fix it.
That's not the way that they should be handling this type of a story. They should be trying to make it right rather than hoping that time will create a new controversy to allow them to not have to address this.
The next thing I want to focus on is the very last thing the chief says, which is a very important issue to us. And she says, quote, Mr. Massucci has the right to remain silent, but would have been well served to explain his side of the events when he was given the opportunity, close quote. Now, folks, this is just blaming Matthew for being innocent, for being falsely accused, for being wrongfully charged, and getting the case dismissed.
And then there's the last line of the email.
Mr. Massucci has the right to remain silent, but would have been well served to explain his side of events when he was given the opportunity. What do you think about that?
He is arrested at gunpoint with many officers pointing many guns at him. He's taken into custody, and then an officer comes in or a detective comes in to interrogate him, and he says, you know what, I'd rather have my attorney present and not talk with you guys. I think Matthew did exactly the right thing.
These people are professional interrogators. They are trained to interrogate you, and not only are they allowed to lie to you, says all of the case law, they are trained to lie to you to try to get you to incriminate yourself. So this little closing line on the email here seems to be an attempt at trying to encourage the public to waive their right to remain silent. Don't do that.
And she wants to shift blame onto him for all of the things that they failed to do.
The attorneys also say the email continues to treat Matt as if he's guilty, and it does not detail the false statements made by the Parra family.
The guy went out, grabbed a gun from his vehicle, and then came back to your husband and pointed it at his chest?
Correct. at his heart.
This sounds like the chief giving somebody legal advice, and quite frankly, I'd rather rely on the Constitution. I don't think Mr. Massucci should have given away his constitutional rights, his right to counsel, his right to remain silent, and just trust the Prescott Police Department. I think he did the right thing by trusting the Constitution and not the police chief in this case. Another thing I'd like you to look at is the factual information that the chief provides. And you're going to see this email yourself. Again, it's very lengthy. You're going to see all the different issues that are raised in it. So I'm not going to point them all out, but I am going to point out something that we thought was the most important factual piece of information in this case. That is the fact that the Parra family made specific accusations against Matthew that were very, very important from a legal perspective. And if you go back and look at some of the previous information we've provided, one of the main areas of contention is, where did this event occur? Was it inside Matthew's car with Chief Parra standing in the doorway refusing to let Matthew leave, or was it completely outside the car, either between the vehicles or even over by the Parra's vehicle? The way the Parra family describes this, if you recall, is that Matthew came out of the store. He is, saying things to their family, looking at their daughter, walking around their truck, saying he's going to attack their 15-year-old son, all sorts of things. Then they say that when Chief Parra got out to confront him, Matthew went to his car, got a gun, came back, pointed the gun at Chief Parra at his chest and at his heart, and essentially assaulted him in that fashion.
As he was walking out, he was giving looks to my children who are in the front two seats driving their parents home, and he started talking to my son. My son said, "What back?" My husband jumped out of the back seat, and the guy went and grabbed a freaking 9mm and pointed at my husband's heart.
The guy went out, grabbed a gun from his vehicle, and then came back to your husband and pointed it at his chest.
Correct, at his heart. When the second the guy realized that he was fire, he was freaking out, jumped in his car, and freaking sped off.
That's not the facts, as you know. You've seen the evidence where this altercation occurred when Chief Parra approached Matthew, wouldn't let him close his door, and was going at Matthew while Matthew was seated in his car trying to leave. Why is that important? Well, that's again important because of the legal posture of the case, which we're going to get into in just a minute with another thing that the chief has said here. But the important thing is, as you look through that email, you're going to see that nowhere does the chief acknowledge that the Parra family gave all of this inaccurate, incorrect information to law enforcement, in effect, still somehow giving the Parra family the benefit of the doubt, and at the same time blaming Matthew, saying Matthew should have done something other than just be innocent and defend himself. For some reason, that set of facts never makes it into the email that she sends to the city officials. Next, the police chief tells the city officials about Arizona self-defense law. Now again, I can't get in the chief's mind. I don't know what's going on here. What I do know is that when you're going to talk about the law that applies to a case, talk about the law. And what the chief does here is provides a reference to kind of a generic self-defense law in Arizona. It's ARS 13-404. And it's kind of an overarching self-defense law that describes your right to defend yourself in most situations. But what the chief doesn't talk about is the very specific self-defense statutes that our legislature has passed to address this exact situation. And that omission, for whatever reason, is very telling, in my opinion.
Another reason these lawyers call the email a cover-up is they say it misleads the council and other city leaders about self-defense laws.
I don't know what's on her mind. I would hate to think that she's trying to mislead anybody.
The email highlights, literally, just one statute about self-defense, saying it's not justified in response to verbal provocation alone.
So again, she gives you ARS 13-404. You'll see that. And you can also go to the internet. If you type in Arizona revised statutes, you'll go to the Arizona legislature's website and you can pull up ARS 13-404 and you'll see that there. But the statutes that she does not reference and does not pass on to the city officials are the ones that are actually applicable to this case and super important.
If somebody's trying to enter your vehicle, you're allowed under Arizona law to use deadly force in order to stop that intrusion. None of those statutes were discussed in this email.
The first one is ARS 13-418. It's use of force in defense of a residential structure or occupied vehicle. And that's probably the most important thing here, is that Matthew was in his vehicle along with his girlfriend at the time. So they're in an occupied vehicle. And ARS 13-418, as you will see on your screen there, gives you very specific rights to defend yourself. Then in conjunction with the very next statute, ARS 13-419, which talks about the legal presumptions that you're given if you are in an occupied vehicle, you read those together, and this is what we meant in our earlier videos when we said Matthew Massucci, at that moment in time, had every right to threaten deadly force and actually to use deadly force. In other words, he could have shot and killed Chief Parra because Chief Parra was attacking him in his occupied vehicle. The other one that's really important that, again, gets no mention in this email is ARS 13-421, which is the defensive display of a firearm statute, which specifically allowed Matthew to display the firearm. And all he had to do was meet the qualifications of this statute, which he clearly does, and he can display the firearm to prevent the chief from attacking him, which is exactly what happened. That's what the Arizona legislature passed years ago so that we could prevent people from being attacked. Matthew did that, and he was then lied about and charged. So what are we left with? Well, Matthew Massucci is an innocent victim. He lawfully defended himself. He was arrested at gunpoint, as you've seen in our videos. He was held in jail for days before he could bond out. He had his life destroyed while this case lingered on for 2 years. Now, according to the chief, it's apparently Matthew's fault that he invoked his right to counsel, his right to remain silent, and his privilege against self-incrimination. The takeaway here, folks, is stand your ground. And I don't just mean stand your ground in the sense that you have the right to stand your ground and defend yourself when somebody's attacking you. I mean stand your ground legally and lawfully when you're being falsely accused. Invoke your constitutional rights. Don't give them up when somebody tries to talk you out of them. Get a great criminal defense team to fight for you. Here at Attorneys for Freedom, we are a law firm that represents our members at Attorneys on Retainer. We fight for the rights of our clients across the nation. We are the only law firm that is dedicated to self-defense across these United States. So for those of you who would like to get more information about Attorneys for Freedom, again, we're the law firm that backs you and represents you as an AOR member. Whenever you have an issue and you call, we're the ones that are answering the emergency line. We're the ones who are responding. We're the ones who are representing you when you need it around the nation. Go to attorneysforfreedom.com. You'll learn all about our law firm there. You can see who the attorneys are and who the team is that's going to be helping you out. You can also go to our website, attorneysonretainer.us. Please check out the benefits of being an AOR member. If you've seen our earlier videos on this case, you know that Matthew Massucci was not an AOR member at the time this happened, and he and his family searched us out, hired us to represent him. And if you've seen the videos, Matthew is very adamant that he wishes he had been an AOR member at the time this happened. Please listen to these videos. Please don't wait until something happens to you and you have to hire an attorney individually to defend your rights and your family. One of the other issues that we would really like you to be aware of, folks, for AOR members and for those of you who are looking at AOR as a program that you might want to join, we have recently rolled out a major new benefit for our members, which is the 4 Attorneys in Trial benefit. So we've talked about this. I know we've released some separate videos on this, but when somebody is going to trial in a felony case where their life, their liberty, their future is at risk, you want to have the absolute best defense team possible. When you see some of these high-profile cases or some of these high-profile individuals go to trial, you'll notice they're not going with 1 attorney or 2 attorneys. They've got a full team of folks who are working for them. Attorneys, paralegals, experts, investigators, all of those folks. Here at Attorneys on Retainer, when we go to trial on felony trials, we have told our members you are going to have 4 attorneys with you in the courtroom in your trial. That is such a critical thing to have, and I can tell you I have done a number of high-profile and very serious felony trials. And having other members of the team there ready to help you, ready to take turns handling difficult witnesses or addressing the issues as they come up with the judge, that is very critical. Folks who can afford it always have it. Well, if you're a member of AOR, you can afford it, and we will have it there for you. To stay up to date with everything on Matthew's case, as well as what we've got going on with AOR, please like, comment, share, and subscribe on our YouTube channel. I know we'll have more information coming for you soon on Matthew's case. Stay tuned. And if you have questions, please post them. We'll try to get them as quickly as possible. Thank you very much.